Welcome to the Deep Dive.
Glad to be back.
Today we're tackling a pretty significant Supreme Court case. It really gets into how much power Congress can, hand off.
Right, we're looking at Gundy v. United States.
And this one zooms in on SORNA, the Sex Offender Registration and Notification Act.
Specifically, a part of SORNA, Section 2913 Twain. The big question was, did Congress give away too much of its lawmaking power to the Attorney General there? Is that constitutional?
Okay, so a delegation of power issue,
Yep.
And the bottom line from the court.
The bottom line is the court said it was constitutional. They upheld that section.
All right, so our mission today is to really unpack that. Why did they decide that? What were the arguments flying back and forth?
And what does it mean for, how laws actually get made and put into practice?
Exactly. Okay, let's dive in. First, the basics of the holding.
Sure. So, Justice Kagan delivered the judgment, joined by Justices Ginsburg, Breyer, and Sotomayor.
A plurality opinion, then.
Yes. And they concluded Section 2913 Twin doesn't violate what's called the non-delegation doctrine.
Which is basically the rule that says Congress has to do the legislating, right? It can't just pass the buck entirely to another branch.
Precisely. And the court found that this specific delegation in SORNA, it easily passes the test. It's constitutional.
Okay, so let's get specific. What does this Section 2913 actually do? You mentioned SORNA registration.
Yeah, so subsection B of the law sets the general rule for when offenders register, usually before they finish their prison sentence or within 3 days of sentencing if they're not imprisoned.
Seems straightforward enough. So where does D come in?
Subsection D is about the offenders who were convicted before SORNA was even a law.
So they couldn't possibly follow the rule in B because it didn't exist yet.
Exactly. So subsection D says the Attorney General needs to figure out how to apply SORNA's registration requirements to these pre-act offenders.
How? Does it say how?
It says the AG must do it as soon as feasible.
As soon as feasible. Okay, I can see why someone might argue that's a bit vague. That sounds like a lot of leeway for the Attorney General.
And that's really the crux of the argument. But the court looked at this through the lens of the intelligible principle standard.
Right, the classic test for delegation. Congress just needs to lay out some kind of understandable principle to guide whoever they're giving the power to.
Exactly. And they pointed out, referencing Whitman v. American Trucking, that these standards don't have to be, super strict or detailed.
The bar isn't incredibly high, historically speaking.
Not at all. The court reminded us they've only struck down delegations twice in history. And those were pretty extreme cases.
Like the Schechter poultry sick chicken case and Panama refining?
Those are the ones. Cases where Congress basically offered no policy guidance, no standard at all, just, here, you figure it out.
Whereas here they have as soon as feasible.
Right. And the court said, compared to delegations they have upheld in the past, like giving the FCC power to regulate broadcasting in the public interest in the NBC case, this SORNA delegation is, quote, distinctly small bore.
Small bore. Okay. So relatively minor in the grand scheme of government delegations.
That was their view. They basically said, look, if this is unconstitutional delegation, then frankly, huge chunks of the modern administrative state are probably unconstitutional too.
Because Congress delegates power all the time to let agencies actually implement complex programs.
All the time. They cited the Mistretta case, noting that Congress simply can't function without being able to delegate power under broad directives. It's a practical necessity.
Okay, that makes sense from a practical standpoint, but how did they analyze the actual language as soon as feasible?
Well, they stressed that any non-delegation question has to start with interpreting the statute itself.
You need to figure out what the law says first.
Exactly. What task is Congress actually delegating, and what instructions, even if general, did they provide? You construe the statute to see if that intelligible principle is there.
So it wasn't just about plucking out those three words, as soon as feasible.
Definitely not. They pushed back against looking at words in isolation. You have to read them in context within the whole structure of SORNA.
The classic statutory interpretation rules. Look at the whole act.
Right. Context, structure, and even the history and purpose behind the law. Why did Congress pass SORNA? What were they trying to achieve? All that helps give meaning to the words, including the scope of the delegation.
So the overall goal of SORNA, protecting the public, creating a comprehensive registration system, informs what as soon as feasible means in practice.
That's the idea. The court suggested the context makes it clear the AG's job wasn't to decide if pre-act offenders should register, but how and when, logistically, to get it done efficiently and effectively.
Okay. Now, Justice Alito agreed with the result, but he wasn't fully on board with the reasoning, was he?
Correct. He concurred to the judgment, meaning he agreed SORNA was constitutional under the current rules.
What?
But he rose separately to say he thinks the court should seriously reconsider its whole approach to the non-delegation doctrine in a future case.
So he's signaling he might be willing to tighten the rules on Congress in the future, put more teeth into that doctrine.
That seems to be the signal, yes. A willingness to revisit how much delegation is too much.
And then there was the dissent, led by Justice Gorsuch. He had a very different take.
A very different take indeed. Justice Gorsuch argued forcefully that the Constitution vests all legislative power exclusively in Congress. Period.
No wiggle room.
His view is that making general rules for people's conduct, that is legislating. And Congress can't just farm that job out to the Attorney General or anyone else in the executive branch.
He saw this as a fundamental violation of the separation of powers.
Absolutely. He invoked history, the Federalist Papers, the framers' intent, arguing that concentrating the power to make laws and the power to enforce them in the same hands, especially the chief prosecutor, is dangerous.
Did he distinguish this from older cases where delegation was allowed?
He did. He argued that cases like J.W. Hampton, which established the intelligible principle idea, involved much narrower delegations, like setting customs duties based on specific factual findings. He felt SORNA gave the AG far broader, essentially legislative discretion.
And he wasn't persuaded that, as soon as feasible, provided enough of a standard.
Not at all. He basically saw that as Congress telling the Attorney General, you decide when and how these pre-act offenders register, which he viewed as Congress improperly handing off its core legislative duty.
Yeah.
He rejected the idea that the law's general purpose could supply the missing standard.
Wow. Okay, so a real division on the court about what this non-delegation doctrine means and how strictly it should be applied.
Definitely. It highlights a fundamental tension.
All right, let's shift gears to our 10th chair segment. Imagine you're the 10th justice. You've heard it all. Where do you land on Gundy?
Okay. Sitting in that hypothetical 10th chair, that's tough. I think I'd ultimately agree with the plurality that under the court's long-standing precedent, the intelligible principle test, as it's currently understood, section 209(13)d, probably passes muster.
So you'd vote to uphold the statute?
Reluctantly, yes. As soon as feasible, especially read in the context of SORNA's overall aims, does provide some guidance. It's not a completely blank check. It tells the AG to get it done, consider the practicalities, don't delay unnecessarily.
But you sound hesitant. You share some of the concerns raised by Alito or Gorsuch.
I do. I absolutely share Justice Alito's unease. While feasible might be intelligible, it's undeniably broad. And we're talking about applying registration requirements, which has significant liberty implications. Giving the executive branch, specifically the Attorney General, that much discretion over who gets covered by the law and when, based on such a flexible standard, it makes me uncomfortable.
Because it feels like the AG is making policy choices Congress should have made more clearly.
Exactly. It blurs the line. While I understand the practical need for delegation, Congress can't foresee every implementation detail. This feels like a significant policy judgment being delegated. In an ideal world, Congress would have provided a more concrete time frame or clearer criteria for feasibility in an area like this. So while I think it squeaks by under current doctrine, the case definitely serves as a strong reminder for me in the 10th chair that maybe that doctrine needs another look, as Justice Alito suggested. The balance between efficiency and maintaining distinct legislative power is tricky, and Gundy sits right on that edge.
A very thoughtful perspective from the 10th chair. It really underscores the complexity here.
It's not simple.
Well, that concludes our deep dive into Gundy v. United States. We've explored the court's reasoning, the dissenting views, and the really fundamental questions about delegation and the separation of powers.
It's a case that really gets to the heart of how our government is structured and how it operates in the modern world.
Hopefully this discussion has shed some light on this important legal doctrine. It makes you wonder, where else does this issue of Congress delegating broad authority pop up? What are the potential consequences?
Important questions to keep asking.
Definitely. We encourage you to keep exploring those. Thank you for joining us on the deep dive.
Thanks for listening.